Tonight, for the first time, we hear from the man who scored a major victory for working parents' rights in Minnesota. David Prickett was fired in 1991 when he refused to work a late shift because it would mean leaving his boy home alone. As Mike Binkley reports, it's a case that made it all the way to the state Supreme Court.
Here, you want to put him away?
This single father felt he was being forced to make a terrible choice 3 years ago, a choice between his job and his son. David Prickett's boss told him he had to switch shifts. He'd suddenly be working 4 to midnight. And when Prickett couldn't find childcare for those late hours, he refused to work the new shift and was fired.
Yeah, I went to, I'd say about 6, 7 outfits, all the way from here to where I worked there in Plymouth.
On top of his firing, the state told him his actions constituted misconduct, so he couldn't collect unemployment. Prickett appealed that decision all the way to the state Supreme Court and won. The court in the process threw out 2 rulings from the 1950s that said employees who can't find child care are unavailable for work and in turn not eligible for unemployment. The Supreme Court pointed out that society has changed quite a bit since the 1950s, that 60% of Minnesota children now have 2 working parents. Besides that, if he would have gone to work without finding daycare, he could have faced child neglect charges.
What do? Stick him in a closet and lock it so that he's safe and go to work and come back and then let him out once I'm home?
Prickett's attorney says the ruling is a victory for parents throughout the state.
Employees can now be assured that if they do find themselves in Mr. Prickett's situation, they will at least get the benefits.
In Zimmerman, Mike Binkley, Channel 5 Eyewitness News.
The court's ruling doesn't mean that Prickett's boss was wrong to fire him. It simply means that since Prickett made a good faith effort to find child care, he is eligible for unemployment.